Some commercial farmers are not happy with plans to introduce black shareholding if they want new water licenses. Under the new draft proposal, farmers will be compelled to have 75 or from 25 to 75% of shareholding to qualify for the licenses. Farmers' bodies, including Agri-SA, say the planned regulations will make it more difficult to access financial support. We're now joined by Annalise Crosby, Head of Legal Intelligence at AgBiz. Thank you very much, Annalise, for your time this afternoon. Perhaps let's start with an understanding of the environment when it comes to water licensing. Currently, what does the landscape look like?
Yes, okay. So let me first of all just say that AgBiz represents the agricultural value chain. So, you know, we have everybody from financiers to input suppliers and associations that represent commercial producers as members. The licensing provision per se is not new. It stems from the Water Act, which is quite an old piece of legislation that originated in 1998. And in the Water Act, there is a provision, Section 27, that deals with the allocation and renewal of licenses. And that provision states that when somebody applies for a water license, there are a number of factors that need to be considered, one of which is the designated groups that did not get an opportunity to get access to water rights in the old dispensation, and how redress can be done to also make it possible for them. Now, regulations have been published now by the department with a 60-day period for inputs, whereby they are trying to give content to one of the factors that need to be considered in Section 27, and that is that redress factor. And the way in which they have now done it is they're saying basically that if you need to apply for a water license, or whether if you want to renew your water license, they're going to look first and foremost whether or not, or at your black ownership component. And the implication is that you will not get a water license if you're using more than the specified 250,000 cubic meters of water for taking from a resource or storing, or if you are irrigating more than 100 hectares with the water.
And what then seems to be the issue of contention with some of those you represent?
Okay, so a lot of the producers are still on a system that is referred to as existing lawful use. So the idea in 1998 was that eventually everybody should obtain a license, but it has taken a very long time to change those old order rights into licenses. Now, those farmers have been basically investing in the land with the existing rights that they had, on the understanding that they would be able to continue to do so. And it's very, very expensive to put in the kind of infrastructure that you need, for example, for wine farming, vineyards and orchards, etc. So if those farmers now need to apply, because it seems that they want to shorten the period for commercial licensing, and bring that in sort of on a general scale, if those farmers were now to apply for licenses, or those who have for renewal of licenses, they might be confronted with a situation where they will not get those licenses because they don't comply with the specific component of black ownership. And the problem is that, first of all, the focus is on ownership only. The Black Economic Empowerment legislation actually provides for a lot of other factors such as management and skills development and enterprise development and all of those things. Those won't count for anything if you apply for a license. And also the other factors that need to be considered to make this a holistic sort of process whereby decision making takes place are disregarded completely. Things like the kind of money that has been spent on investment, the strategic importance of the water use. Because what many people don't know is that we have actually very little arable land in this country that you can grow crops on, and also 90% of things like our wine and fruit, and also a lot of vegetables and potatoes and cotton, etc., is produced under irrigation. So if those farmers no longer have access to water for irrigation, they would no longer be able to farm with those crops, and there's likely to be financial damages which can potentially have an impact on the whole value chain.
You mentioned that it has taken time to change the old order rights. What does that mean, and why has it taken time?
Okay, so before the water law came into being, if you had a river running through your property, then in many cases you had a right to use that water. That was sort of considered as part and parcel of your property rights. When the water law came into being, then it sort of divided that, said that you're not automatically the owner of the water. If you're the owner of the land, the state became the custodian of land, and then this whole licensing system came in. But because of the potential danger of quickly converting everything into licenses, and exactly because, there was infrastructure involved and food security involved and all of that, there was a long process of what they call verification and validation of these rights undertaken. And for various reasons, this has just taken a very long time. So the Act provided for the possibility that the Department of Water could do this on a sort of a piecemeal basis, so they could publish a government gazette for a specific area where there was a river or irrigation happening, and then ask everybody in that area to apply for licenses, or people could also voluntarily apply for licenses. But that process has not been finalized.
And so what options are available to those you represent? You mentioned that there's a 60-day process of consultation.
Yeah, so it's critically important that, everybody who is worried about this should actually make use of the opportunity to now comment and explain exactly, what they foresee the unintended consequences of this could be. We have a lot of interaction with the Department of Water and Sanitation, and they actually have an open door as far as business and the agricultural sector is considered. So hopefully, they will take this into account when they publish the final regulations. So that is where our focus is at this point in time.
Annelies Crosby is the head of legal intelligence at AgBiz. Thank you very much for your time.